Hello, everybody. I'm Richard Moore, and we are honored to have today with us former State Supreme Court Justice Daniel Kelly, and of course, he's running to be a Supreme Court Justice once again in the February 21st primary, and then the top two will go to the April 4th primary. So, Justice Kelly, glad to have you with us.
Well, it is a pleasure to be with you here. Thanks so much.
Okay, let's get off to a start with a non-judicial question. Just fill us in on your background. Everybody knows you're a former Supreme Court justice, but so often we don't really know where these folks come from before they got to their position. We still don't know where Barack Obama came from, really. So why don't you give us a little background of your life?
That'd be great. So I came to Wisconsin when I was 18 years old. So I was born in Santa Barbara, grew up, most of my growing up years were in Colorado, just on the east side of the Rockies. And I came out to Wisconsin because growing up, our family didn't really have much. And if I was going to be able to go to college, it would have to be based on savings and whatever financial aid that I could get. And a recruiter from Carroll College, Waukesha County, flew out to Colorado. She called me up, said, I want to talk to you. And so I did, and she put together a great package for me and that I could actually afford to go to school. And so I came up to Wisconsin, never been here before, didn't know a soul in the state. But the funny thing was, I fell in love with Wisconsinites the very first day I was here because of the very first people I met. So I love fishing, and so I've been told by the recruiter that there's great fishing in Wisconsin. Turns out that's true.
That's true.
So I came out a little bit early so I could get some fishing in before study started. And so I found myself at a park in Waukesha County on a lake, and the first day I got here, and it was a beautiful, beautiful weekend. And the rest of Wisconsin thought so too, because they were all there. It was crowded. All the campsites were taken, but I ended up sharing a campsite with a young family from Sheboygan Falls. Okay. And they're just the most remarkable folks. And they spent basically a long weekend teaching me what it is to be a Wisconsinite. They had me to their campfire for dinner. We talked into the wee hours of the morning, took me sailing, and it was just a delightful time. And I came away from that thinking I had just had the most marvelous stroke of luck, because clearly I had just met the most generous, warm people in the entire state. And, I learned pretty quickly after that although they were remarkable, they weren't unique. So I found people like that at school and at work and at church and at other parks all over the state of Wisconsin. And I learned that people of Wisconsin are the people of the open hand and generous heart. And they still are that today. And I fell in love with Wisconsinites so much that I married one. We met at Carroll College, and we've been married 33 years now.
Okay, congratulations.
Thank you. It is, and they are my treasures. They are my treasures. So, and our 5 kids are almost all grown. The youngest is 16. So she's still at home, and like I said, they are just treasures to me.
You know, I must tell you, I am from South Carolina originally.
Okay. And
my wife, Lisa, is from Wisconsin, and that's how I got to Wisconsin. I actually met her in South Carolina. She was working down there, and she had an opportunity, and we decided to take it, and we came north and fell in love with Wisconsin. And now, as we get older, our 30th anniversary will be next year. Okay. And, or actually this year, the end of this year. And the more we look towards retirement and retirement age, it's like, well, let's go back to South Carolina. And Lisa's actually made the leap down there now already. And I spend as much time as down there as I can. But, it's awful hard to dynamite me out of Wisconsin and the Northwoods in particular. Here I am in the middle of winter.
Yeah.
So,
Yeah. Well, I think it would be especially hard to get you out of Minocqua. I mean, this is just beautiful.
It's beautiful any time of the year, but boy, I tell you what, in the summer and the fall, it's just paradise.
Stupendous, yes.
All right, so, and by the way, everybody, Justice Kelly has informed us that we have a lot of time to spend here, so get your drink and popcorn and settle back because it could be a while. It's not one of these, and I hate it when you get candidates who come in and it's like, well, you got 10 minutes.
Yeah.
And it's like, well, what can we do in 10 minutes? Nothing. You might as well go on your way. Yeah. I'll give one of our favorites was Scott Walker. He gave us lots and lots of time. He would sit there and he didn't give us much time to get in a word in edgewise, but he gave us plenty of time.
He has a lot to say.
He has a lot to say. All right, so I want to begin. Two of the things I want to talk about today, and then you can open up with what you want to talk about too, is the administrative state and the relationship between the judiciary, the legislative, and the executive branch. But before we get to that, let's talk about core philosophy. We look at these Supreme Court races, and we hear conservatives say, "Well, I'm for the rule of law." It's what the law states, not what I want the law to be, which is what the liberals do and practice, and they do. Yeah. I often call it, conservatives like the rule of law and liberals like the law of rule. And but expand on that in terms of the real world examples. Can you give me an example, a tangible example of what that means so voters who hear this can put it in on each side, both what it means to the rule of law and what it means to actually be an activist? Yeah,
absolutely. So I think probably, and this kind of gets to the administrative state too, with this example. Probably the best example are a brace of cases decided over the last couple of years. So I don't know if you remember COVID. I've been trying to forget. Barely. I've been trying to forget. I would just rather
block it out.
Yes. But that order, the Safer at Home order, I'm sure you'll remember that. So Secretary Palm goes into her office in Madison one day, and she taps out a brand new law. She prints it off and she holds it up and she says, "Behold my law." and just to make sure that people understood that they were not suggestions, at the end of that order provided that people who disobeyed her law could be criminally prosecuted. So that was an extraordinary order, and you'll remember that it told everyone they had to stay at home unless Secretary Palm said they could leave.
Yep.
Said that all businesses had to close unless Secretary Palm decided they were essential. Couldn't send your children to school, couldn't go to church. And it was so detailed that it even taught you how to properly cough and sneeze. So a thoroughgoing piece of legislation. But that's what the problem was. It was legislation. So that order came to the courts in right quick fashion for us to address, because there was a claim that it was an unlawful order. And so we decided that case, and the decision was 4-3. And I think that's significant. That should have been a 7-0 decision, because it was an obviously unlawful order. Now, the decision of the court was, well, you didn't go through the proper rulemaking process. And on that basis, it's an unlawful order. And Justice Rebecca Bradley and I, we both joined that opinion, because that's true. It didn't go through the rulemaking process, and therefore it was unlawful. But that was just the surface problem. The really significant problem there was the violation of the separation of powers that it represented. So as you know, our Constitution provides that we've got 3 branches, and the first of them, and the most important and the central, is the legislature, right? And that's the way that our framers have constructed this. Same thing with the United States Constitution, right? So the United States Constitution, it's Articles 1, 2, and 3. Legislative is 1, executive 2, judiciary is 3. Ours is in the same order, but it's 4, 5, and 7. So legislature 4, executive 5, 6 some administrative offices, and then bringing up the tag end, where it belongs, by the way, the judiciary in Article 7. And that's important because the judiciary is just a law-deciding court. It doesn't make the law, right? It doesn't carry out the law. It just resolves the people's controversies according to the law that already exists. So the question is then, well, what do you do with that when one of the branches oversteps its boundaries and tries to exercise the authority of a different branch? What do you do? And for Justice Rebecca Bradley and I, we look at that and we say, well, we have to say that that's what occurred. So we looked at that order and what we saw there was legislation. And of course, we look at Article 5 of the Constitution. It says all the legislating power is vested in the Assembly and the Senate. All of it. It didn't say, well, except for when Secretary Palm has a really good idea for a law, right? It says all of it. So we said, yes, it did not go through the proper rulemaking process, but it was also unconstitutional because the executive stole the legislative power to make the law. So that's what we said. All right, so now this is what it means to be a constitutional conservative, is to privilege the Constitution above all else, above your own personal politics and preferences, to prioritize that over executive orders, and even to prioritize it over statutes. So if there's ever a conflict between the statute and the Constitution controls. So that's what it means to be a constitutional conservative. The flip side of that is to be an activist. So I mentioned that the Palm case was 4-3. So the three, they looked at that order and they said, well, I think that's a good idea. But that's not the question.
That's not the question to be decided, right?
It's not. Whether it's a good idea or not is not for the court to decide, right? And so that's really one of the chasms that exist between constitutional conservatives and activists. They look at a law and they say, is that a good idea? Is it efficacious? Is it efficient? Is it promoting a worthy goal? And if it is, okay, well, we'll go along with that. And if it's not, if we don't think it is, they'll knock it down. And constitutional conservatives, we look at it and we say, well, we might not think it's a very good law, but that doesn't matter because the people of Wisconsin have not asked us to make that judgment, right? So they tell us, as I look at the Constitution, I see that they've told us, look, we want you to do one thing, just one thing. Please do it well, but it's just one thing. Decide our cases according to the law that already exists. Don't you worry about whether it's a wise law or
bad,
efficient.
good law, right?
Yeah, we'll take that up with our legislature if we think we've got a problem with that, right? We've got a branch of government to decide those questions. We just want you to do this one thing. Stay in your lane and do that. So that's the way I approached when I was on the court every single case that came before us. Now, I think as I mentioned, there's a brace of cases. So now, I was on the court when we decided Palm. I then leave the courts. That question came back, but this time at a local level. So the public health official in Dane County looked at Secretary Palm's order after it was struck down and said, oh, I like that. I think that's great stuff. And we're going to do that in Dane County. So that became effective in Dane County. And so the question was, well, wait a minute. Public health officer is in the executive branch at the county level, not the legislative branch. So people looked at the Palm decision and said, well, Justices Kelly and Bradley said separation of powers is important here. And so that came back to the Supreme Court, and the court decided that case on a 4-3 decision too, except it was the other way around. And so the court upheld that, and then I don't want to get ahead of ourselves here, but interestingly, one of the justices who was in dissent in the Palm case, but was in the majority in the Becker case, that was the one in Dane County, in a separate opinion, he said, that separation of powers, that's a lot of political talk, really. It's not. It might not really be a legally enforceable constitutional command, which to me was shocking because the separation of powers is what sets our form of government apart from everything else.
It's essential.
Yeah, it is the living heartbeat of that Constitution. If you take that out, if that's not a constitutional command that is legally enforceable, then we don't really have a constitutional order, because then just each branch gets to do whatever
it wants.
Yeah.
Very good, and thank you for explaining that. Now, I want to turn, before we get back to this administrative state and everything, I want to turn to a critical issue that's national today, and that's the First Amendment. Mm-hmm. First Amendment's under attack everywhere, and unfortunately, all too often, I think, particularly among younger generations, a lot of younger people don't even believe in the First Amendment. They'll tell you, you don't have a right to say anything you want. So the cases that have been exploding, the Twitter files and all this stuff, has been talking about big tech censorship, Twitter censorship, and they've revolved around such things as when does a private corp company become a state actor, and so therefore it becomes a First Amendment issue. I want to ask you not so much about when it becomes a First Amendment issue, but what is the First Amendment and from your philosophical viewpoint? Mm-hmm. We had a Democratic senator a few weeks ago who said, well, hate speech is not protected by the Constitution. We have our public health establishment remind us endlessly that misinformation is not protected under the First Amendment. So what is the scope of the First Amendment? Is misinformation protected? Is hate speech protected?
If we ever get into a position where we are dependent on the government to tell us what is and is not true, then we've completely lost the thread of the story of a free people, right? So first off, a caveat. So there are some restrictions on what I can say as a judicial candidate. So I can't give legal advice, and I can't specifically address a question that may come before the court.
Right.
But what we can do is we can kind of talk about principles and the way that you address these kinds of issues. So I'm reminded that way back in 1787, when we were constructing the Constitution, and then in 1791, when we were adopting the Bill of Rights, our concern was this. We had just shuffled off the bands of an overreaching and tyrannical government. And the framers' concern was, look, we've got a project before us, and the project is we have to construct a government that has enough power to effectively govern, but not so much power or concentrated in a particular way that it would be able to take away our liberties. And so their first concern was really, all right, we gotta cabin in this government so that we can be free and self-governing people. And so when we got to the Bill of Rights, the concern was, if we are going to be self-governing, we have to have no restrictions in our communications with one another, because that is the way that we figure out if our government is doing the things it ought to be doing, and more importantly, whether it's doing things that it ought not to be doing. And so the idea of the idea of putting the government in charge of deciding what is information and what is misinformation, they would look at us with just boggled eyes and go, what are you talking about? We did this. We put this together specifically so the government would not have a role in what we say to each other. No, their job is to stay out. And really, in a lot of ways, it's kind of it's a jurisdictional statement, right? So it's not, we don't have the First Amendment because most of the time it's a good idea to have freedom of speech. We have the First Amendment because the government has no authority to restrict our speech. And so whether that's, when people engage in hate speech, now there could be many different descriptions of what that is.
That's right.
But I was raised as a Christian, and part of that is respecting and loving others, right? Doing unto them as you would have them do unto you. And so I don't like hate speech, But the question is it up to me to control what someone else says?
Right.
And that First Amendment is a jurisdictional statement that says, no. A free people, they don't get to be free just when they agree with you, just when they are pleasant, just when their speech conforms to the etiquette that you follow. Being a free people means that there's going to be bumping and grinding that is uncomfortable at times because people will make different decisions. And so the idea that we would empower the government to control what we say would strike the framers as an absurdity. I don't think anything has changed as a practical matter on that analysis. Today, just as it was in 1791, 1787, it would be absurd to give the government power to tell us what we may or may not say.
That's well said. I'm reminded, and I can't quote it off the top of my head, but I'm reminded of Thomas Jefferson when he said that true liberty is the rights of the individual, delimited not by the law, because law is often but the tyrant's will, but by the rights of others. And I think that, it gets to the point of where the framers were. They were astounding people. Yeah. So I want to move closer to home, and in particular to northern Wisconsin. You spend much time in northern Wisconsin?
Not nearly enough, but I come up every summer to do some fishing. And so it would be lovely if I could spend more time, but that work thing.
That work thing, I know how that works. Well, we have a lot of issues here, and so that will come up today is DNR, Department of Natural Resources. They're just the face of the bureaucracy to many people up here. Yeah. And when I first started working in this newspaper a long, long time ago, early 2000s, and that was the second time around. But at the time, the publisher here, Greg Walker, came in and he said, "I'd like you to do some investigating for me." He said, "The DNR is just completely out of control. They're causing people's homes to be torn down. One couple had gone like $1,000 at that time. They had the 50% rule and what you could maintenance of your home, and gone over by $1,000. It was the contractor's fault that made them tear the house down, move it back." And so he's going through these horror stories after horror stories, and he's asking me to investigate. And quite frankly, we laugh about this now. It's like, I went home with my wife. I said, "This guy's crazy. There's no way that the government is really doing all this stuff." And then as I investigated, I discovered that not only was the government doing all the stuff he told me about, it was even worse than that. And so the DNR has become this face of talk about writing law on a whim. And now in recent years with a different administration, they're back at it again. One issue that comes up all the time is the issue of, and you can only speak to this however you can as a candidate, but you were involved in a case, Steets, I think it was called, where it was a trespass case, where the DNR wardens came upon a guy on his own land, and I think it was the end of hunting season, and they saw his vehicle, and that to them said, "Oh boy, he's illegally hunting." And so it made it obviously all the way to the Supreme Court, and that case was returned to the circuit court on the probable cause question. But you and Rebecca Bradley also brought up the issue of whether trespass and the ability of the government to be able to walk willy-nilly on your land for no probable cause, which the DNR, and by the way, the DOT does too, they claim the jurisdiction to do that, often based in the open fields doctrine. We had a case a year ago where that happened here on a baiting case. Well, they came upon baiting, and the guy was illegally baiting, but how did they know about that? They were just wandering through the land, and we've had this through the years, and it continues to come up, so much so that this county, Oneida County, has rewritten its ordinance to make sure that its zoning staff knows they can't go on people's property without permission or without probable cause. all of this circles back around to the open fields doctrine. What's your take on it? And in terms of your imploring that the court should have addressed these trespass issues.
Yeah. So, and of course, I can only address this in kind of conceptual terms, right?
Yes, right.
So it turns out that property rights are real, and our Constitution does not make exception for that for those who simply want to wander onto property to see if there might be something going on that should not be going on. Now, clearly, law enforcement is with anyone else. They can look, standing on public property or somewhere else where they have permission to be. They can look and see what they can see. Right. But those property lines are real property lines, and one of the first rights of real property is the right to exclude, and that means everyone, even when an agent of the government really, really wants to be there. We've developed a whole body of law surrounding how it can come to be that a government agent can go on private property, and I think we should respect that. And I'm walking right up to the line on what I can say about this, because I expect that this will.
I think we come back to.
Yeah,
yes,
I think so. So what I would say is that property rights and constitutional rights combine to give people some pretty significant protection against government intrusion. And of course, how that's going to work out in a specific case, I can't address, but it kind of goes back to what we were talking about before about why we constructed our government the way that we did. And it was to protect our liberties and to protect our properties, and we need to take that seriously.
Yeah, there was a case, it's been 5 or 6 years ago, but here in Oneida County, there's a potato farmer over in the western part of the county. His name is Sawinski, Alvin Sawinski, older guy than his son Paul Sawinski. So some DNR wardens were sitting in a cafe over in Sugar Camp or Three Lakes one day, and they overheard somebody say, well, they're poisoning bald eagles over there. They get because they don't want them around the potatoes. So that was enough for the DNR, and they got the Fish and Wildlife Service involved in it, and they go right on the property, and they find, to make a long story short, over the course of about a 2-year investigation, they placed cameras trying to catch the Sawinskis poisoning eagles. Never found them. Mm. They sent in an undercover cop who tried to lure him into poisoning eagles and killing other wildlife. They didn't bite on that either. They set up, the trail cameras. They had the undercover cop. They even planted a poisoned bald eagle on their property, and ultimately they sent in effectively a SWAT team of like 50 agents early in the morning, one of those deals, into their house to arrest these guys. In the end, they never could. They found they found 2 poisoned bald eagles. One they thought was incidental to a pesticide that is now banned but was then legal that potato farmers used. And then, of course, there was the one that the state planted itself, which, as it turned out, that's what they ultimately got them on because when the Sawinskis found that poisoned bald eagle, they took they disposed of it rather than reporting it. So they got him on an illegal thing then, and that was the end of it. But the length and of something that started off as a hunch was just amazing to me. And this is one more example of how sometimes our constitutional rights as well as our property rights at the same time are being violated. But that's the kind of stuff that happens all the time up here.
Well, and that goes to the importance of making sure that our executive agencies are being controlled by the legislature. Right. So one of my projects actually, after I left the court, was I was asked to write a manual on legislative oversight.
I was going to get to that.
Yeah. And so in part of that, I described at length the type of authority that the executive has, the type of authority the legislature has, and the type of authority the court has. And why it's so important that each one of them exercise only the authority that the people of Wisconsin have lent to them, and not using the authority they lent to other branches. And, in this this question of whether executive agencies are staying within their boundaries is something that the legislature can and should be always looking into. So one of the responsibilities of the legislature is not just to make the law, right? So their job is not to just cast their work out under the water and then turn around and walk away. When they send their laws out into the public, their responsibility is to do that and then watch. Is it being enforced the way that they had anticipated? Is it having the consequences that they anticipated? Has it accomplished its goal? Should it then be repealed or amended or whatever it might be? And that normally takes the form of oversight over the executive branch, and because they're the ones that actually carry it into effect. And so I wrote that manual to give them a guide on how to do that in an effective way. So it's a step-by-step guide. After I provide the history of the authority and the philosophical basis for doing it and why it's important to do it, step-by-step guide on how to actually do legislative oversight investigations and hearings, all the way from conceptualizing what you're going to investigate, all the way through how to actually conduct the hearing, gathering the evidence and the witnesses and presenting that in a hearing that would be persuasive and would be capable of actually moving the needle on the thing that you're doing oversight on. And so I think that's the primary place. Our framers put the legislature in the lead of the government for a reason. We have a tendency to think of the executive as being the lead of our government. That would surprise the framers.
That would, wouldn't it? Yes. Yeah. That's where we've really gone on our heads in the modern era.
Yeah. So the framers looked at the legislature and said they're the really significant actors in our frame of government. They get to make the law and then decide when it's accomplished its objectives, when it needs to be changed, when the new laws need to be added, and that's the motive force of government. And so their responsibility is to make sure that the executive branch is doing the job that the legislature told them to do.
And that brings me to a decision where I disagree with you.
Right.
But a little background on before we get to it. So we go back to the Doyle years.
Yeah.
And we go back to when I was beginning investigating the DNR. And the state agencies just completely out of control. They're writing administrative rules. They're subverting the legislature's intent. Mm-hmm. One of the most significant examples. By the way, before I get to that, this manual that you did, is that available to the public?
It is. They can find it at reforminggovernment.org.
Okay. And I'll also post a link to it.
Great.
And we'll do that as well, because I think that would be, I've read it, I think it's a great read, and it would be an interesting read to listeners and readers. Going back to this, so the DNR, the best example I ever came up with was the Job Creation Act. So they passed this law that's going to streamline permitting on development projects on the waterways. Mm-hmm. So then they delegate to the DNR to write the rule to implement the law, mm-hmm. And part of that would be to come up with a list of sensitive waterways that this rule would not apply to. So the DNR sets about in their wonderful way, and they set about and come up with virtually eliminating every waterway in the state of, they're all sensitive, of course. And so it was just, and they were brazen about it. And you even had the Sierra Club come out and say, well, we love what the DNR did with this rule because it reinstates what the legislature took out from us, took away from us. It didn't work in this case because for some reason Doyle stepped in and actually overturned it. So and signed the law. They didn't get away with it, but they get away with it, and they've gotten away with it on many cases. So then you get Scott Walker and company, and the GOP legislature come in, and they start to chip away and roll back at administrative rules. Mm-hmm. And they did the REINS Act, which I don't think goes far enough. It lets way too many of these rules pass because you got to have a $10 million threshold. And the DNR comes in with an analysis and says it's no impact, none at all.
It's free.
So they need to be stiffer. But anyway, they tighten down on them. So then the DNR decides, and other state agencies, we'll use guidance documents to get our way. And that's exactly what they've done. Now, in a 4-3 decision in the lame duck laws, the legislature tried to rein them in as well. Mm-hmm. You voted it out and said, nope, it became a separation of powers issue. Right. Could you explain your thinking on that decision?
Yeah, absolutely. So the place to start, I think, on that is recognizing that guidance documents and rules are different things. So a rule is something that has the force of law. So someone could be held accountable to what that provides. And we could have a very fruitful discussion about what the scope of an executive agency's authority is to promulgate rules. But at least under the way they're currently understood, rules have the force of law.
Right.
Guidance documents don't. So here's how the legislature defined the guidance document. They said that a guidance document is the executive's understanding of how the law applies. It also said that guidance documents cannot create any legally binding obligations, cannot create a standard against which people's behavior can be measured, and specifically said does not have the force of law. And so the provision that was at issue in that case was about the process that the executive would have to follow in promulgating a guidance document. And so there was a certain notice period and comment, and then the executive would have to account for the comments in the guidance document, and there were a few other miscellaneous restrictions on how the guidance documents get promulgated. And so the question became, does the legislature have the authority to tell the executive how to develop its guidance documents? And where we start with the analysis there is with the legislature's decision that guidance documents don't have the force or effect of law. And once you decide that, and you say, as the legislature did, that a guidance document is merely the executive's understanding of how the law applies, and then it can't create any standard or conduct whatsoever, well then a guidance document just becomes a written expression of the executive's thoughts. And the question is, can the legislature legislate the executive's thoughts? And the answer, of course, is no, because the executive's thoughts are his own. And it's actually his constitutional obligation to do his own research into how the law applies and develop his understanding of how it applies, and then do that, right? He has that obligation because when he takes office, he puts his hand on the Bible and swears to uphold the Constitution, right? And part of his job, and I've described some of this in the Legislative Oversight Manual, is to develop that understanding of the law and do it conscientiously and in good faith, and then execute on that. And then it's possible for, if he gets it wrong, the court can address that. And if the legislature looks at what he does and they say, oh, you know what, maybe we weren't explicit enough, we need to tighten that up, then they can go back and do that. But the executive's thoughts are his own. They're not subject to legislation.
Now, I see the strict technical legal logic behind your thinking there, but it leaves us sort of with a catch-22 in a way.
Okay.
The legislature can't step in and tell the the executive branch how to think.
Yeah.
I think Hagedorn's point to that was it's not really trying to tell them how to think, but looking at the outcome of their thoughts, which I think is at the heart of the question. Also, to the point about judicial review, Roggensack said, well, we pointed out in Palm that judicial review is not adequate to overcome the deprivation of liberty in the first place. So I think those are points. But the essential thing is, okay, if you can't step in because technically these documents don't have the force of law, but in the real world they do, then we've got a problem where you cannot contain or control the administrative state. That seems to be, and stepping a minute just beyond the candidate, but the person, Dan Kelly, that decision has unleashed, we know it from the DNR and other agencies as well, and they're telling people, well, this is what's going to happen if you do that, because we have reinterpreted the laws. We've got a situation right here. So the DNR comes in, works with not with the county, not with the elected officials, but with a lakefront association, association. And they decide that, well, the Oneida County Shoreline Ordinance is not compliant with state law. And they rewrite, and then they bring it to the zoning committee, and they say, okay, here's what we need you to do. And by the way, the DNR signed off on this with their guidance. And the DNR says, sure, we did, because it's obviously not, it had to do with the vegetative buffer zone, obviously not compliant. So the zoning committee will say, well, wait a minute. Isn't our shoreline zoning ordinance certified by the DNR? There's been no change in administrative rule. There's been no change in law. And it's been certified. Well, it wouldn't be certified, they say, if it were presented to us today, and it might be challenged, and it could be challenged, and if it is challenged, then there's going to be a superseding law put in place. They're still doing it. And so this has led to a whole revision now that's ongoing. Yeah. And now it's expanded into other areas with the DNR saying, no, you cannot do this, no, you cannot do this, no, you can't do this. This is all DNR guidance. Yeah. And the county's backed into a corner, being threatened by the DNR. We have this all across the way. Is there no way then to contain the administrative state from using, I wouldn't say, I guess loophole's not the word, but okay, a technicality, because it might not be legally the force of law, but when counties and people are threatened by a state agency, it is the force of law.
Well, let's unpack that a little bit. So when we say that it has as a practical matter the force of law, what we mean, I think, and correct me if I'm wrong, what we mean is, well, this is what they do. And the regulated community, whatever the regulated community might be, experiences that as an agent of the government coming in and telling them what to do. When they look at the law and they're like, wait a minute, I don't think that complies with what the statutes say or what the rules say, right? So that's, I think that's what we mean when we talk about feeling like it has the effect of law. All right, so the first place to start is that it does not, you might experience it that way, but it is not law. The only law that exists is what is in our Constitution, our statutes, and our rules. Now, executive agencies can go out and act in a way that is not consistent with that law. And that doesn't make their actions law. It makes them violative of the law. So let's take a look at that in the context of guidance documents. And let's say that that we said, well, you know what, the legislature does get to tell the executive what to think about the law, and go through the process, and you put out the proposed guidance for comments, you incorporate the results of those comments into the guidance document, and then it gets promulgated. Is that really going to control what the executive thinks about the law, or how he acts in relation to the law? No, all you've got is at that point, all you have is a document that says, well, this is required by the legislature to write up, and the governor or the executive branch agency could disregard that just as well and easier than disregarding a rule or a statute or a constitutional provision.
That is true, but isn't it also? I mean, didn't the law that you guys rejected 4-3, wasn't that before a guidance document could be enacted or published, that it had to come before the legislature?
No.
What exactly was that?
So the guidance document, it never has to come to the legislature. And again,
right.
Yeah, because it's just the executive's thought. Now, proposed rules do, and that was upheld in SEIU versus Voss. And that actually, not to get off the guidance documents too much, but just as a footnote, that gets rulemaking a little bit closer to constitutional standard, because our legislature is the one with the authority to make the law, so they should probably at least see it at some point before it becomes effective. So having a proposed rule go back over to the legislature so they can at least get their eyes on it means that they at least have an opportunity to shut it down if they think that it's not a proper exercise of law. So, but with guidance documents, let's look at it this way. Let's say the executive agency decides, well, you know what, I want to mess around with the regulated community, and I'm not going to publish a guidance document at all. There's no requirement that I do. The proposed legislation simply said that if you do, this is how you must do it. But there's no requirement that they issue any guidance documents. The executive is still going to have thoughts about what the law is and how they're going to enforce it. So the question is, what is the significance of the attempt to have the legislature have an input into how the executive develops the guidance documents? At the end of the day, there will be no difference whatsoever if you have to go through that procedure that the legislature provided for, because the executive's going to think what the executive's going to think, and he's not going to be bound by a document that he didn't want to put together in the first place, right? So he can either write the document that he wants to write, that it has no force of law, or he can write a document that the legislature says you have to account for these things, still has no force of law. Now the executive looks at that and says, well, those aren't my thoughts. What I think is actually what I would have written. Which one of those do you think he's going to follow in execution of the law? Of course he's going to go with what he actually thinks
That's true.
the law says. So that guidance document not only doesn't constrain him, but now it's kind of misdirection. Because you've got a document out there that might not actually reflect what the executive agency really thinks. And so the executive agency is going to go out there and do what he really thinks, not what a document says. So even if there was authority for the legislature to try to tell the executive what to think about the law, that will always be doomed to failure as a practical matter, because you're not going to change what the executive thinks just because you make him jump through a few hoops before he issues a document.
True, but okay, from the legal standpoint, what the executive truly thinks and how they get around that process of if there were a process for guidance document, that's not a legal question.
Right. So now you've got the practical problem. What is he doing? Right.
Right.
All right. So the question then is, regardless of the guidance document reflecting what he actually thinks about the law, he's out there doing things, and it either does or does not comply with rules, statutes, or constitutional provisions. All right, so what do you do? So now you're in the same position as you always are with the executive. And how do you control the executive and keep him from violating the law? Well, there's a couple ways. One is why I wrote the oversight manual, so that the legislature gets involved and says, wait a minute, we see what you're doing there, and that's not what our statutes say, and we're going to investigate you to figure out why you're doing this. And then you're going to come in and we're going to have a hearing, and you're going to have to publicly justify what you're doing. And we are going to bring all of the evidence to bear on how you are not following the law, right? So that's one way. The other way, and this is what a part of what the legislature provided as well, is that guidance documents are challengeable in court. So if a member of the regulated community sees a guidance document and says, wait a minute, I don't think that complies with the rules or the statutes or the Constitution, you can go directly to court and challenge that guidance document. You can get a declaratory judgment that that guidance document is not in accord with the law. So that's the other way that you can address an executive agency going beyond their lawful authority.
Well, I like the two alternatives there,
mm-hmm.
and that makes a great deal of sense. I mean, if the legislature can step in with an oversight hearing and saying what you're doing in Oneida County, we're going to investigate, or what you're doing over here, whether it's a guidance document or not, it doesn't comply with the statute and the rule, then or legislative intent, then they can hold a hearing. I like that. Yeah. Now, the question I have, and I don't know the answer, is on the challenging of a guidance document. Does that have to first go to an administrative law judge?
That goes right to court.
Goes right to court.
Yep.
What do you think about overall in terms of is this whole I call them kangaroo courts, the administrative law proceedings?
Yeah.
Do you think they're constitutional?
Well, now that's a fine question. Let me get at that in a way that I think would be appropriate for a judicial candidate to talk about. So, and just to make sure I was accurate in a prior response, when I said that you can go directly to court, that's for guidance documents?
Right.
Yeah. Okay.
That
was your question.
Yeah, that was the question. Right.
So the authority of executive agencies to adjudicate. We can get at this a little bit through the DNR or the Tetra Tech versus Department of Revenue decision.
Yes.
So the question there was which branch of government has the authority to declare what the law says? And interestingly, if we rewind our clock about 100 years, long time ago, courts started deferring to executive branch agencies' conclusions of law. And it started out innocuously enough. The court would say, well, look, this is in the administrative agency's area of expertise, and we're gonna listen carefully to what they say. They're the experts, and we're going to pay particular attention to that. That metastasized over the long years, and eventually it became a standard of review, which was just remarkable. When we would say as a court, we will give varying levels of deference to an executive agency's conclusions of law, depending on their level of expertise and several other factors. But the upshot of it was that there would be circumstances in which the court would look at one of the litigants in a case, right? Because this all happens in litigation. So there's the administrative agency, they're on one side of the courtroom. On the other side of the courtroom, there's a member of the regulated community, and they've got a disagreement about what the law says. Mm-hmm. And they come to court, and the executive agency looks at the judge and says, Judge, our determination is that the law says X. And that's not a suggestion. You need to defer to me on that. And then the member of the regulated community is looking at that and going, wait, hang on just a second. I thought we had judges to decide that sort of thing. And the judge says, well, normally you would think so, but,
no.
This is what he says the law means, and so I got to follow that. And so we looked at that situation in Tetra Tech, and I wrote an egregiously long opinion. I think it was 80 some odd pages. But in my defense, we had to go back and unpack 100 years of precedent and detailing where that went off the rails to the point where a court would be saying to the executive branch, "Oh, you decide what the law means. We'll just do whatever you tell us." And what we did is, and this was a lead opinion, which means we did not get a majority. So there was a majority to agree with the conclusion that we're not going to defer to executive branch agencies anymore in deciding what the law says. But only 2 of us, Justice Rebecca Bradley and I, said this is a constitutional problem. We've allowed some of the judiciary's authority to escape over to the executive branch.
Exactly.
And it's time for us to repatriate that authority where the Constitution puts it, which is in the judicial branch.
You're right. The administrative law proceedings, that's a can of worms, and both on the national level. I mean, there's being litigated there, and
you've noticed that I've neatly avoided answers.
And I'm not going to ask you that because I know you can't answer it. But I will give you just an illustration of what we're just writing about here. So there's a DNR case, and there's a guy. He's got 200 acres somewhere in Wisconsin, and he got a little bluff of land up there, and he wants to build a cabin, and he calls the locals out there, and they say, well, you can build a cabin, and you can build a little driveway across this little sliver of wetland here, not a four-wheeler trail.
Okay.
But then he decides, well, my cabin really needs to be a 4-bedroom house, and my four-wheeler trail needs to be a real driveway. And I'm not defending this guy by any stretch of the imagination. So he builds the driveway. He doesn't get any permits. He doesn't get anything. So then there's a complaint, and the county comes out and said, oh, no, and the DNR comes out, no. So he goes for an after-the-fact permit, and they deny him. So it goes before the administrative law judge. Now, the state says this is perfectly fine because the administrative law judge doesn't work for the DNR, works for the DOA, although they work with the same people, hear the same agency cases over and over and over again. So it's still all executive branch. But, all right, so the guy says, well, there's no other location for the driveway except right over this wetland, which the DNR acknowledges it really isn't a very sensitive wetland. But the administrative law judge says, well, that's not the case. The case is whether the house can be located somewhere, not just the driveway. Then that goes against DNR policy, but that's a separate issue. So they go on about this whole thing, and they say, well, we can't build out on alternative B because Heidi Kennedy was a DNR wetland manager, and she was now working for this guy who's saying you'd have to have an outdoor septic. It's not feasible under anything, but they had alternative A. And the administrative law judge absolutely said, I know a building site when I see one, which is better than the one you've chosen, and that's alternative A. And so we can select that one even though it's substandard from logistics, proximity to the roadways, to all of these factors. And he said, well, what about property values? My property value has no view. My property value is going to be devalued. She said, well, we don't care about property values. So she considered all these other factors, but not property values. And then they had the DNR saying, and this is one I love, over the sliver of wetland, well, there's a thing called aesthetic non-natural deterrent. And everybody's like, what's that? And that's, well, the wolves and the coyotes won't really like the road. You know, they're aesthetically repelled by the road, and they won't cross the road, and this fragments their habitat. The administrative law judge buys this nonsense and says, well, this is biologists everywhere have embraced this. I Googled all this stuff. I never could find any of it. So, and she didn't cite anything except the DNR. And plus, you could build on alternative A, even though it was under a farmland preservation zoning district, and the house wouldn't be farmland. But then they brought the zoning director in who worked with the DNR and said, well, you know, the use of the land is really immaterial. ALJ said fine. So they lose. All right, so now all this stuff, they go to circuit court. Now they can go to circuit court, but by statute, circuit court is limited there. You can't have a jury trial. You're bound by the record of the ALG, and basically you're facing a stacked deck there too. So you're going to lose. Yeah. Now they go to the appeals court. So then the appeals court, now it's a different situation. The appeals court said, now they got a different zoning administrator and they bring in this farmland stuff. They said, you really can't build a house there. There really is no practical alternative. And this needs to go back to the circuit court. So it goes back to the circuit court. They overturn their original judgment. Now they've sent it back to the DNR, and we're going all through this all over again. And you've got this thing, if you had gone to circuit court in the beginning, I don't know whether you would win or lose, or whether the circuit, or whether a jury or a judge would find that aesthetic non-natural deterrent actually exists. Mm-hmm. But it would seem like a much direct and more be in a constitutional court when you're aggrieved than a state agency.
Yeah, so that's a great example, and again, I'll only be able to kind of poke around the edges of this. So let's take a look at what's happening in executive agencies. Whenever you're administering a program or a set of statutes, you've got to figure out how those apply in any given circumstance. And so there's always the possibility that there will be factual questions that arise in how that standard of law applies to that given situation. And the executive has to figure out, well, are the facts inside or outside of this standard? And they've got to make that call. Right. One says enforcement action, one says, no, we're good here. And so it makes sense to have some kind of formalized process by which you hear both sides of the story, and then you make a determination on whether this it warrants enforcement action or does not. Now, the difficulty, I think, the question that comes up is I hear it in your question, as I've heard many times, is, all right, so that's the executive's determination. But if this then comes to a court case, why is it that the executive, one of the parties to the case, gets his own set of facts?
Right.
Right?
That's right.
And, and I think people in Wisconsin would look at this and say, well, fact-finding seems a lot like what courts do.
That's right, isn't it? Yes.
So, we oftentimes say, and, in court trials, the court does two things. It finds facts and it concludes law. And so, that sounds like a court thing to do.
It does sound like a court thing to do. Yeah. Okay. Well said. I do want to get you out of here because we've been going on over an hour. I don't want to keep you all afternoon. I know you've got a long drive. A couple of quick questions. You were asking a forum, I'm not sure where, what you thought one of the worst U.S. Supreme Court decisions was, and you said Kelo. I happen to agree with you, by the way, but explain why you think that is.
It encompasses so much that is wrong with how a court can just blow it as a court. So first off, there's the problem with reading language out of the Constitution, right? So the Fifth Amendment protects against the taking of property, but for public use. And we know what public use is, right? So it's a roadway, it's a spot to build a government building. It's a place to have a military installation, something like that. The standard, however, has metastasized over the years, and it has become public purpose instead of public use. Mm-hmm. Well, purpose is an extraordinarily expansive and broad word. And
big surprise.
Yeah, how what kind of things wouldn't fall in to the category of public purpose? And so So not only did it read out a very significant and useful word out of the Constitution and replace it with something more expansive, but then over the years, the court worked on even that word, the purpose word, and made that grow and grow and grow and become more expansive, until we get to a point in Kelo in which the court says, well, taking property from one private owner to give it to another private owner that's a public purpose because we think it's going to have good economic effects. And with that, the Supreme Court of the United States announced that your property is not really a right, it's a privilege, and you hold it only so long as the government can't think of a better thing to do with it.
Yeah.
Right?
Right.
And so, the insistence on law that our framers had, and on the protection of personal liberties and property rights, the property rights part just went away. I mean, you probably know that in the Declaration of Independence, when it said that we are endowed with certain unalienable rights, that amongst these are life, liberty, and the pursuit of happiness. What they meant by pursuit of happiness was property rights.
Property rights.
And so, in that part of the Constitution, or of the Declaration of Independence, goes on to say that governments are instituted for the purpose of protecting those rights, right?
Right.
And so now the Declaration, that language is not part of the United States Constitution, but it is part of our Wisconsin Constitution.
Yes.
It's Article 1, Section 1. It's the very first thing that we said in our Constitution. Governments are created to protect those rights. And so I look at Kelo and I see a court that willfully and without regard to the Constitution simply said, but the government has better ideas on what to do with your property. And that's just fine. I think that's a horrible decision.
I agree with you. Last question. Well, first, before I get to the last question, any issue that I haven't brought up that you would like to address?
Yeah, I've got like 20 years of it. But no, I think for our purposes today, I think that covers it pretty well.
All right. Primary, February 21st, and
Yeah.
I'm sure as readers and listeners know, this is a very, very important Supreme Court race. We've talked about a bunch of issues today, due deference, where the courts handed all sorts of power over the years, both state and nationally, to the administrative state. The legislature has virtually, at some point, tried to give all of their power away to the administrative state. We got lots of problems. Now, in this election, we got 4 candidates. We got 2 conservatives and 2 liberals, as it's practically defined. If one of the liberals win, there's a new Supreme Court majority, and that's going to be 4-3, sort of. You never know how somebody's going to vote, but it certainly changes the equation. And when you look back over the last few years and look at all the decisions that you guys, Justice Kelly, have dealt with, and the Palm decision, the taking away of civil liberties, thank God we had a conservative Supreme Court to stand up for those civil liberties. So it's a very, very important election. Now, in terms of the conservative side of things, I'm sure the conservatives are going out and liberals are going out. We've got Jennifer Doro is your opponent on that side of the stuff. Why, number one, should conservatives vote for you rather than her? And number 2, why should voters overall elect you to the Supreme Court?
Yeah, those are great questions. So I guess the way I would look at it is this, and I want to go back to part of what you said. Thank God for decisions like the Palm decision, right? And I've heard folks around the state of Wisconsin and tell me that they were grateful that I was there for that, and they would thank me for that decision. And I always say, well, I'll accept your thanks on behalf of the framers of the Constitution, because I was just doing what the Constitution told me to do in that case, right? So I can't really accept the thanks, because it wasn't like I was looking at that and saying my personal values tell me that order's got to go down. What I did is I looked at the law and I said, what does the law command that we do? And I did that. All right, so I think that's the hallmark of a constitutional conservative. Now, you mentioned the balance of the court being 4-3-ish.
Ish.
All right. So the ish has a name.
Yeah.
He came to us, going on 4 years ago now, and he said, I'm a constitutional conservative. I'll uphold the Constitution. I'll preserve the rule of law. I'll keep politics out of the courtroom. And we took a gamble on him because there wasn't really any record that we could point to and say, well, because of these things, we are confident that he will, in fact, uphold the Constitution, and that he knows how to, and that he will preserve the rule of law, and that he knows how to. So it was a gamble. And I took that gamble too. I campaigned for him. And then he came to the court, and what I found was something different from what I expected. I expected that along with Justice Rebecca Bradley, he would be focused in on the Constitution like we are, and focused in on our statutes. Excuse me. And that his sole guiding philosophy would be the application of the Constitution and our statutes. And what we found was that for whatever reason, he didn't do that. And I think the Palm and the Becker decisions are a good example of that.
Right.
So, in the Becker case, saying that it's really more political philosophy than a legally enforceable constitutional commandment in the separation of powers. And so one of the things that taught Rebecca Bradley and I was, well, we better make sure the next time this comes around, we can point to a record. And indeed, that's what I've, over this last year and a half or so, as I've traveled around Wisconsin, talking about these kinds of things, what I've heard over and over is, we don't want to gamble next time. We want to make sure that the person that we send to the Supreme Court knows how to do this and has a long track record of doing it, because the best indication of what you will do is what you've done in the past.
Yes.
And so, they say, and that's you. You have that, and so we want you to go back to the Supreme Court. Now, that's both part of the reason that I'm running, and why I think that out of the four candidates, they are kind of divided into two camps,
right?
Even though it's a jungle primary,
yeah,
right?
Yeah, right.
Yeah.
Yeah.
So that's also one of the reasons why I think that that people in Wisconsin prefer my candidacy over Jennifer's. So Jennifer tells us that that she is a judicial conservative, and that she will uphold the Constitution and the rule of law. And while those words are encouraging, I remember Brian.
That's right.
Saying the same thing. And so I say, okay, well, let's take a look. What background do you have that would give us confidence that if you went to the Supreme Court, that you would do, let's say, as Justice Rebecca Bradley does? What do you have to give us that comfort level? And basically, what we have is her words. And so, I think we're in the same, with Jennifer, we're in the same position we were with Brian. Do we want to take a gamble? And maybe somebody, maybe some people do, and they want to gamble. Okay, that's up to them. But given what's at stake in this election in April, I'm not sure that'd be the best thing to do. Back when Brian was up, there wasn't a concern that the activists would get control of the courts.
Right. That's right.
But now there is. And so the question is, one, who has the background, and two, who has the demonstrated ability to take the argument to the activists and effectively push that back, not just in the general election, but then when you're elected to the court, because there's already 3 activists there.
That's right.
And you will spend the next 10 years pushing back against that, making sure that the court's work is focused on the Constitution and the statutes. And so, I encourage people to take a look at the debate that we had a couple weeks ago. It was the first debate of the election cycle. And so there, the 4 of us were lined up on the stage. Everett Mitchell to my left, Janet Protasewicz to my far left, which seemed appropriate. And they let their colors fly. Yeah. And so the question is, can you take the argument to them? And I think if people watch the debate, they'll see that I was really the only one there who was able to bring the argument to them and demonstrate that what they were talking about was outside of the bounds of what a properly constituted court would do. And so, and I think, in saying all of this, I don't want to take anything away from Jennifer and the work that she's done on the trial court. I think she's been a good trial judge. But this is a wholly different thing. And it calls for a different skill set and different experience. And I think that was on display in that first debate. So, right. Jennifer, and I think she's very smart, but because she doesn't have the background that I do in dealing with these issues, she's just not fluent in them. And so, to participate in the debate, she had a binder of prepared statements. And when she was asked a question, she'd flip to a place in the binder and then read a prepared statement. And if that's where you're at as a candidate, then my suggestion is that perhaps you're not ready yet, right, to be on the Supreme Court. And so I think that when people are when those of our fellow Wisconsinites who want a constitutional conservative on the court, my suggestion is that having a long public record of doing constitutional conservatism is essential. And so, in my background in this is lengthy. I mean, I was, as you know, I was appointed by Governor Walker to the Supreme Court in 2016, but I was already a well-known constitutional conservative by that time, because in addition to my practice at one of the largest firms in the state, I'd also helped lead the Federalist Society, and that is an educational organization whose sole purpose is to promote the proper application of the original public meaning of our constitutions, and in particular with respect to the courts in that constitutional structure. And so I did that for 15 years before coming to the court. The last 5 of that as president of the Milwaukee chapter. That was one of the most vibrant, still is one of the most vibrant chapters in the country. And I've written about this extensively, both on and off the court. And I've given probably over 100 lectures all across Wisconsin on the proper role and function of our court system. And then in addition to that, I think we have right now 2 premier constitutional conservatives in our judiciary. One is Justice Rebecca Bradley in the Supreme Court.
Absolutely.
And then the other is Judge Shelley Grogan on the Court of Appeals. And they both endorse me. And I think it's important why they endorse me. So they looked at each of the candidates, all 4 of us, and they studied our records carefully. And their conclusion is that I am the only constitutional conservative in the race. Now, I think that Jennifer's entirely capable of becoming that, and I would certainly encourage that. And I would love to see that, but we just don't have anything to indicate that she's there right now. So my hope is that she does develop in that direction. But as far as who's ready to to go against the activists, I think that's me. Now, that gets to the second part of your question. So that was a long first part. How long do you have today? So now, you've probably heard, as I have over the years, an election comes up, and we're told this is the most important election in our lifetime.
We hear it every election.
Every single time we hear that. So I'm not going to say that. But I will say, what the consequences are, and then people can decide how important that might be. So, as I look at this, I think probably the best way of looking at the consequences is to listen to what Janet Protasewicz says. So she's the Milwaukee County Circuit Court judge who's running, and I've been amazed at how brazen she has been about her promise to disregard our laws. Mm-hmm. So I'm put in mind of an article in the New York Times from back in the summer, actually. They were writing about this election, this Supreme Court election, and it was remarkable. They said that the left's objective, if they were to capture this seat in April, is to completely politically transform the state of Wisconsin. And further, that they would take all of the policy desires that they haven't been able to get through the legislature, and they just impose them through the courts.
That's right.
So I thought that was a remarkably brazen statement of what they want to do with the court. But then time passes and I find out that I'm wrong. Oh, it gets worse than that. So in that debate a couple of weeks ago, Janet was asked about the redistricting map, right? The court dealt with just this past term. And I thought she'd say something that a jurist would say, such like, we deal with legal questions. Maps, there's a lot of political considerations to go into that, but we only do legal questions. And so if it comes to the court again, that's all we'll address is whatever legal infirmities it might have. But that's not what she said. She said, that map is rigged. It's unfair, it's unrepresentative, and she says she's got to fix it. Well, when you hear a judicial candidate telling you that she's going to fix it because it's not representative, she's telling you she's going to bring her politics into the courtroom.
Absolutely. And
make decisions on that basis. So I thought that hit the new high water mark.
I think so. I think it does.
Yeah. And then last week, Sunday, I saw her on Capital City Sunday, and it was even more remarkable. She was asked, the interviewer said, well, people have referred to you as a progressive judge. How do you respond to that label? And again, I thought, well, she'll say, well, we're not politicians. We don't do political things. And so, it's just about the law, not about my progressive politics. And instead, she said, oh, I embrace that term. I am a progressive judge. And then it went downhill from there because, then they were talking about the scales of justice. Right,
oh boy.
And it's it's a metaphor for what we do, and so the idea is that you hold that scale straight, true, and fair, and you don't put your thumb on it. Right. It is It is meant to embody the impartiality of the jurist. And so she was asked about that, and she says, "Well, in the vast bulk of cases, I won't put my thumb on the scale."
In the vast bulk?
In the vast bulk. And I thought, wait just a minute here. So what you're telling us, you in your own words, you're telling us there are cases in which you will put your thumb on the scale, right? And I thought, holy cow, all right, that's the new high water mark for brazenness about just declaring their independence from the law.
Yeah.
And so I think this is what is at stake, and I think it's helpful to put this in a historical perspective. So back in the day, when the framers were talking about why they wrote the Constitution the way that they did, One of the framers, Alexander Hamilton, well known as a Broadway star, rapper, right?
Yeah, right.
He wrote extensively about the courts, and he said that the courts would be the least dangerous branch of government. And that's always struck me because why use the language of dangerousness? Why not efficiency, efficaciousness, right? Why that?
Right.
But if we remember what they were dealing with at the time, it had been just a short time since the separation from England in less than amicable terms, as it turns out.
Yes.
And so their concern was, the reason for the revolution was because of a tyrannical government. It was the government interposing and interfering with their liberties. And so their project was to create a government that would have enough power to govern, but not in a way that would be able to steal away our liberties. And so when they created that separation of powers, that was the whole point of it, is to make sure that those boundaries would make it hard to steal away our liberties. So they looked at the court and they said, well, the court is going to be the least dangerous branch because it has neither force nor will, but merely judgment. All it can do is decide cases, and that according to the laws that already exist. They don't get to make them. That's what the legislature does.
Right.
So don't you worry.
Don't worry about it.
Don't you worry about the courts. And sometimes I think, maybe we look back and we go, oh, Alexander, if you only knew.
If you only knew, yes, absolutely.
But he did. So, when he was talking about it, he went on and he said that liberty can have nothing to fear from the courts. But he says, I mean, if the courts are doing the work of the courts.
You're right.
However, if they should ever combine their power with one of the other branches of government, then liberty would have everything to fear. All right, so now let's take that construct and lay it over what Janet has been telling us over the last few weeks. So she says, the vast bulk of cases, I won't put my thumb on the scale. Vast bulk. All right, so Janet, there will be cases in which you put your thumb on the scale. And what does that actually mean when you put your thumb on the scale? What you're doing is you're declaring your independence from the law. So what are you basing your decision on? Her personal preferences. And she's turning her personal preferences into the law that decides the case. All right, well, what did Alexander Hamilton have to say about that? If you combine the judicial function with the lawmaking function, liberty has everything to fear from that. All right? So let me put it together. Janet has been telling us that if she gets to the Supreme Court, liberty has everything to fear from her. Those are the stakes.
Well said. Justice Daniel Kelly, thank you so much. It's been a great conversation.
This has been a pleasure.
And the February is coming up, February 21st. It's not the most important election of our lifetime, folks, but it's a very important election, so please vote. Thank you.